I've spent countless hours sitting in airport terminals, riding in the backseats of taxis across foreign cities, and having way too many conversations with highway patrol officers during long road trips. And if there's one thing that has always fascinated me, and frankly, worried me, it's the moment when the power dynamic shifts entirely. It's that split second when a law enforcement officer looks at you and asks that question we all dread but rarely know how to handle. Do you mind if I take a look inside your vehicle? I want you to stop and think about a time when you felt that pressure. Maybe it was at a border patrol checkpoint in the Arizona desert, or during a routine traffic stop for a burned-out taillight in Ohio. Maybe you were sitting there, heart pounding, watching the officer's eyes scan your back seat through the window. What did you do? More importantly, what did you say? I genuinely want to know your answer, so drop it in the comment section below. Did you consent because you felt you had no choice? Did you refuse and hope for the best? Or did you sit there frozen, not knowing that your silence could be interpreted as permission? Trust me, your story matters, and the legal implications of that single moment are far more complicated than most people realize. Stick with me, because by the end of this deep dive, you are going to understand exactly what happens inside that officer's head, what the law actually says, and why the choice to say no might either save you or, in some weird situations, make things worse. I've spent years digging into court rulings, talking with defense attorneys, and even riding along with officers to understand how they're trained to handle refusals. The answer to what happens if you refuse is not a simple one-size-fits-all. It depends on where you are, why you were stopped, what the officer sees or smells, and sometimes even the kind of car you're driving. But let's start with the foundational truth that most people get completely backward. Most of us grew up believing that if we have nothing to hide, we have nothing to fear. That phrase gets repeated so often that it's basically become the national motto for giving up your rights. But here's the hard truth I've learned from studying countless cases and talking to lawyers who clean up these messes. The Fourth Amendment to the United States Constitution doesn't protect you because you're guilty or innocent. It protects you because you're you. It protects your privacy, your dignity, and your property from the government, unless the government has a really, really good reason to intrude. The moment you voluntarily open that door, literally or figuratively, you are waiving a constitutional right. And once you waive it, you can't unwaive it. So, let's set the stage properly. You're sitting in your car. The red and blue lights are flashing behind you. Maybe you're annoyed, maybe you're terrified, maybe you're just trying to figure out why you got pulled over. The officer approaches, does the routine license and registration check, and then comes the pivot. Are you in a hurry today? Or where are you headed? Or the direct one. You don't mind if I have a quick look around, do you? That question is a trap, but not in the sinister way you might think. It's a trap because it sounds so casual, so polite, so routine. But legally, it's everything. Here's something I want you to remember, and I'll say it plainly. Consent is the single most powerful tool an officer has to bypass the Constitution. If you say yes, the officer doesn't need probable cause, doesn't need a warrant, and doesn't need to justify anything to anyone. The search becomes legal because you allowed it. And once that happens, anything found in that car, whether it's a bag of marijuana, an open container, or a firearm, can be used against you in court. The lawyers I've spoken with call this the magic waiver, and it's shocking how easily people give it away. But what if you say no? What if you politely decline and say, "Officer, I don't consent to any searches"? This is where the situation gets interesting and where a lot of misinformation floats around. Some people believe that refusing automatically makes you look guilty and gives the officer the right to search anyway. That's not true. Others think that saying no will make the officer angry and lead to retaliation. That can happen, but it's a different issue. The legal reality is that a refusal is your right, and a lawful stop does not become unlawful just because you exercise that right. Now, let's talk about what actually goes through an officer's mind when you refuse. I've spent time with veterans of the Highway Patrol, and they've explained it to me in brutally honest terms. When you refuse consent, you are removing their easiest path to gathering evidence. They now have to rely on their own observations, their training, and the legal concept of probable cause to continue the interaction. And here's where it gets tense. They might try to intimidate you. They might bring a drug-sniffing dog around the car, or they might simply tell you to wait while they write a citation. But unless they have independent justification, like smelling marijuana, seeing a weapon in plain view, or detaining you for a reasonable period to investigate something specific, they cannot legally search your vehicle just because you said no. There's a famous case that illustrates this perfectly. In the Supreme Court decision, Illinois versus Cabales, the court ruled that bringing a drug-sniffing dog around a vehicle during a lawful traffic stop does not violate the Fourth Amendment, as long as the stop isn't prolonged beyond the time needed to handle the original issue. So here's the twist. You can refuse consent, but if a dog alerts to the presence of drugs, that alert gives the officer probable cause to search, regardless of your refusal. Does that make you nervous? It should. It's one of those gray areas where your right to say no collides with the government's ability to use technology and trained animals to investigate. I remember reading about a case in South Dakota, State versus Castleberry, where the defendant was pulled over for a traffic violation and allegedly gave consent to search. The officer found over 66 pounds of marijuana. The defendant later claimed he never actually said yes. He just asked, "Why, did you smell something?" The court had to decide whether that response counted as consent. Ultimately, the court sided with the officer based on the totality of the circumstances. That phrase is crucial because it means judges look at everything: your tone, your body language, your prior experience with police, even your age and education level. If you seem hesitant but ultimately step out of the car and let the officer look, that can be interpreted as consent, even if you never said the word yes. Let that sink in for a moment. Your silence, your hesitation, your nervous laughter, all of it can be used against you. This is why I always tell people, if you do not want the car searched, you must say so clearly and unequivocally. Say, "Officer, I do not consent to a search." Say it politely, say it firmly, and then shut up. Do not explain why. Do not say, "I'm in a hurry," or "I have nothing to hide." Those explanations can be twisted. Just state your refusal and stop talking. Now, let's get into the scenarios that really trip people up. Imagine you're driving a rental car. You're not on the rental agreement because your friend rented it and let you borrow it. What happens then? For years, courts were divided on whether someone in your position had any legal right to refuse a search. But in 2018, the Supreme Court decided Byrd versus United States, and it changed the game. The court held that someone who is lawfully in possession of a rental car, even if not listed on the agreement, has a reasonable expectation of privacy and can challenge a search. However, there's a catch. If the car was rented with the intent to commit a crime, that expectation of privacy might vanish. So, if you're borrowing a car legitimately, you have rights. If you're using it to transport something illegal, the legal landscape shifts dramatically. Another situation that confuses people is the border zone. If you live within 100 miles of any U.S. border, including the entire state of Florida and large parts of states like Texas and California, your Fourth Amendment rights are somewhat diminished. At border checkpoints, officers have broad authority to search vehicles without warrants and even without probable cause in some cases. This is known as the border search exception. So, if you refuse a search at an interior border checkpoint, you might still be detained, and the vehicle could be searched based on reasonable suspicion of immigration violations or criminal activity. It's a different legal universe, and one where being polite and compliant might actually be the safest path, even if it feels unfair. Let's also talk about what happens after an accident. I've seen people get into fender benders and then get blindsided when an officer asks to search the car. The rules here are similar to traffic stops, but with a twist. If the car is being impounded, officers can conduct an inventory search to catalog the contents before towing. That search is not supposed to be a fishing expedition for evidence, but in practice, anything found during that inventory can be used against you. So if your car is undrivable after an accident and you refuse consent, the car might still be searched under the inventory exception if it's towed. The key is whether the impoundment was lawful and whether the search followed standard procedures. Now, I want to address the fear that keeps people up at night. The fear that refusing will escalate the situation. And look, I'm not going to lie to you. There are officers who take refusal personally. There are officers who will make you wait longer, who will call for a K-9 unit, who will scrutinize every detail of your license and registration. That happens. But here's what the lawyers emphasize. You cannot control the officer's reaction. You can only control your own actions. If you refuse consent and the officer searches anyway without legal justification, that search may be illegal. And if it's illegal, any evidence found can potentially be suppressed, meaning it can't be used in court. That's the remedy. That's how the system balances the scales. I've read through case after case where defendants tried to argue that their consent was coerced or that they never actually agreed. One case that stands out is Knight Walker versus Commonwealth in Virginia, decided in early 2025. The defendant was pulled over for driving on a suspended license. The officer asked about weapons, then about drugs, and then asked for consent to search. The defendant didn't say yes. She paused, turned away, grabbed the back of her neck, and said, before the officer pressed further. She eventually got out of the car, and a search revealed drug paraphernalia. The court had to decide whether her actions amounted to consent or just passive acquiescence. Ultimately, the appellate court reversed the conviction, ruling that the stop had been impermissibly extended and that the consent was tainted by the illegal detention. That case is a perfect example of why timing matters. If the officer prolongs a stop beyond what's necessary to handle the original violation, any consent given during that extended period may be invalid. So what should you actually do in the moment? Let me walk you through it step by step based on what I've learned from attorneys who specialize in Fourth Amendment litigation. First, when the officer asks for consent, look them in the eye and say, "Officer, I do not consent to any searches." Do not say no in a way that sounds like a question. Do not mumble. Be clear. Second, ask a question that clarifies your status. Am I free to leave, or am I being detained? If the officer says you're free to leave, then leave. Don't hang around. If the officer says you're being detained, then you're not free to go. But that doesn't mean you have to answer questions. You can remain silent. Third, if the officer proceeds with a search despite your refusal, do not physically resist. Resisting can lead to charges like obstruction or resisting arrest, which carry their own penalties. Instead, observe and remember. Take mental notes of everything: the officer's name, badge number, what was said, what was searched. That information is gold for your attorney later. I also want to touch on something that rarely gets discussed: the role of stop and frisk in vehicle searches. If an officer has reasonable suspicion that you are armed and dangerous, they can pat down your outer clothing for weapons. That's a Terry stop, named after the famous Supreme Court case, Terry v. Ohio. But that pat-down is limited to weapons. If the officer feels something that is immediately identifiable as contraband through plain feel, that can open the door to a broader search. So if you're carrying something illegal in your pocket and it's recognizable by touch, you've just given the officer probable cause. Let's go deeper into probable cause because it's the magic word that changes everything. Probable cause is more than a hunch. It's a set of facts that would lead a reasonable person to believe that a crime has been committed or that evidence of a crime is present in the vehicle. If an officer smells marijuana, that's probable cause. If they see a baggie of white powder on the floor, that's probable cause. If they hear someone inside the car say, "Hide it, cops," that's probable cause. Once probable cause exists, the officer can search the entire vehicle, including closed containers, without your consent and without a warrant. That's the automobile exception to the warrant requirement, and it's been around for decades. So refusing consent doesn't help if the officer already has probable cause. But here's the nuance. Probable cause has to exist before the search. It can't be based on what they find during an illegal search. That's the fruit of the poisonous tree doctrine. Now, let's talk about what happens after the search. Suppose the officer searched without consent, without probable cause, and without a warrant. You're arrested, charged, and sitting in jail. What now? This is where the exclusionary rule comes in. Your attorney will file a motion to suppress the evidence, arguing that it was obtained in violation of the Fourth Amendment. If the judge agrees, that evidence is thrown out. And if that evidence was the core of the case, the charges might be dismissed. I've seen this happen in drug cases, gun cases, even DUI cases. It's not a loophole. It's a constitutional remedy designed to deter police misconduct. But here's the reality check. Motions to suppress are hard to win. Judges tend to give officers the benefit of the doubt, especially in close cases. The Supreme Court has created exceptions like good faith and inevitable discovery that allow illegally obtained evidence to be used if the officer reasonably believed they were acting lawfully or if the evidence would have been found anyway. So while your rights exist, they're not absolute, and they're not always enforced the way you'd hope. One of the most misunderstood areas is what happens when you're a passenger. Passengers have rights too. If you're a passenger in a car that gets pulled over, you are seized for Fourth Amendment purposes, just like the driver. You can't just walk away. But you also have the right to refuse consent to search your personal belongings, like your purse or backpack. If the officer asks to search your bag, you can say no. And if the officer searches it anyway without probable cause, that search may be unconstitutional. However, if the officer has probable cause to search the car, they can search containers that belong to passengers as well, because the scope of the search extends to anywhere the contraband might be hidden. So if you're a passenger and you're carrying something you shouldn't be, your fate is often tied to the driver's. I also want to bring up immigration enforcement, because this is a hot topic and the rules are slightly different. If you're stopped by immigration agents, you still have Fourth and Fifth Amendment rights. You do not have to answer questions about your citizenship or immigration status. You can remain silent. You can refuse consent to a search of your vehicle. However, if you're within 100 miles of the border, agents have expanded authority, and they may use things like reasonable suspicion of an immigration violation to justify a search or detention. In practice, this means that refusing consent might not stop the search if the agent can articulate specific facts that suggest someone in the car is here illegally. It's a volatile situation, and one where carrying documentation of your status, if you have it, can prevent misunderstandings. Let's circle back to the psychological dimension. Why do most people consent? I've thought about this a lot, and I think it comes down to three things: fear, politeness, and ignorance. Fear of what happens if you say no. Politeness ingrained in us since childhood. Don't argue with authority, be cooperative. And ignorance of the law, not knowing that consent is optional. Officers are trained to exploit these tendencies. They're taught to ask for consent in a way that sounds like a routine part of the stop, not a request. They're taught to be friendly and disarming. And they're taught to persist if you hesitate. In the Nightwalker case I mentioned earlier, the officer didn't accept the pause as a refusal. He pushed forward saying, "It'll be real quick." That kind of pressure works on most people. But here's the thing. The law does not require you to be assertive or confrontational. It simply requires that your consent be voluntary. If you feel like you can't say no because the officer has made you feel trapped, that consent might be invalid. The problem is proving it later, in court, without a recording. That's why I always recommend using your phone to record the interaction, if it's safe to do so. In most states, you have the right to record police officers in public, as long as you don't interfere with their duties. A recording can be powerful evidence if the search is challenged. I want to share a cautionary tale from Utah, State versus Arroyo, that shows how messy these cases can get. In that case, the defendant was stopped by a trooper who admitted that the stop was based partly on the fact that the occupants were Hispanic and driving a vehicle with out-of-state plates. The trooper asked for consent, and the defendant agreed. The trial court found that the stop was a pretext and suppressed the evidence, but the appellate court reversed, sending the case back for more hearings on whether the consent was voluntary. That case dragged on for years, and the defendant spent that time under the cloud of a felony charge. The lesson here is that even if your rights are violated, the legal process is slow, expensive, and uncertain. The best outcome is to avoid the search in the first place. So after all of this, what's the bottom line? What happens if you refuse a vehicle search? It depends, but let me give you a realistic breakdown based on everything I've studied. In the best-case scenario, the officer accepts your refusal, completes the traffic stop, and sends you on your way. That happens more often than you might think, especially if the officer had no real suspicion and was just fishing. In the middle scenario, the officer calls for a K-9 unit. If the dog alerts, the car gets searched, and you're now facing the consequences of whatever is found. If the dog doesn't alert, you're probably free to go, but you've been delayed. In the worst-case scenario, the officer searches anyway, finds something, and arrests you. At that point, your fate rests on whether a judge later decides the search was legal, and that decision could take months. What I want you to take away from this is a sense of empowerment, not paranoia. Knowing your rights doesn't make you anti-police. It makes you an informed citizen. Officers have a job to do, and most of them do it with integrity, but the system is designed to give them the upper hand in the moment. And the only way to balance that is to know when to speak and when to stay silent, when to consent and when to refuse. I've spent years traveling, researching, and talking to people on all sides of this issue. And if there's one piece of advice I can leave you with, it's this. Don't let anyone rush you into a decision that could follow you for the rest of your life. Take a breath. Think about what's at stake. And remember that the word no is a complete sentence. You don't owe an explanation. You don't owe a performance. You owe it to yourself to protect your rights, even when it's uncomfortable. Now, I want to hear from you again. Have you ever been in this situation? Did you refuse, or did you let them search? What happened next? Drop your story in the comments, because these real-world experiences teach us more than any law book ever could. And if you're just realizing that you might have handled a past stop differently, share that too. We're all learning here. Thanks for sticking with me through this deep dive. Stay safe out there, keep your head up, and remember that the road belongs to all of us, not just the ones with badges. This response is AI-generated for reference only.